Hello aspirants, welcome to Introspection IS. In our ongoing series of prelims PYQs discussions on polity, we are excited to begin a new topic today, that is judiciary. Kindly continue with us as we carefully analyze this key topic in Indian polity to support your preparations for the upcoming examinations. So let's start the discussions. So we'll start with the very first questions of this series from Judiciary. The first question was asked in 2023. So it said to consider the following statement. So here the two statements given, 1 and 2, and these two statements are in the form of assertion and reason. So first we need to find whether both the statement is true or not. If both the statement is true, so we are left with the only two of the options, that is A and B. If either of the statement is incorrect, then we can easily find the answer through this. Right? So let's analyze the very first statement, that statement 1. It says that in India, prisons are managed by the state government with their own rules and regulations for the day-to-day administration of prisons. So if we see on the logic basis, yes, we have a district jail, we have a state jail, right? So this district jail, state jail comes under the administrations of a state. So on the basis of the logic, we can say that yes, the first statement is true, right? Because every state has a different administrations for their rules and regulations, how they manage their prisons. So the state has power to make the rules and regulations related to day-to-day administrations of prisons. That cannot be given from the, or it cannot come from the above, because we follow the federal relations. We do not find and we do not follow the unitary form of government, unitary form where the power comes from, the above, comes from above. This policy we do not follow. We follow the federal, where the stakeholders are been given power to regulate their own rules and regulations. On this logic, if you are not aware also, see, this type of questions, you cannot prepare for this type of questions. So this type of questions, either you can left this questions, or if you at the end of your examinations, or at the end when you have finished your examinations but you are still left with the time, so you can attempt this type of questions, from where you can use this kind of logic, that on this basis of your knowledge based logic you can analyze the questions, and on this basis you can make your answer. So on this basis, that if suppose that states were not allowed to administer, makes rules and regulations related to their day-to-day prison administrations of the prison, it means there have been delegations of power given by the union. It means unitary, some kind of union control over the regulations of the state government, which is a unitary form of government. So on this logic we can say that yes, the first statement is true, and if the first statement is true and we need to find the correct answer, so A can be our answer, B can be our answer, and C can be answer. The D cannot be the answer, because it says that statement 1 is incorrect. Clear? Now move to the next question. So it says that in India, prisons are governed by the Prisons Act 1894, which expressly kept the subject of prisons in the control of provincial government. So this is an pre-constitutional law. Talking about the pre-constitutional law. Do our country have a provisions of pre-constitutional law? Yes, many of the laws are there, which is existing pre-constitutions, that laws were made by the British Parliament, that has been still been prevailed in some of this law, we can say. So now this second statement requires a very deep knowledge, or it requires an exact knowledge to answer this question. So for this, if you are in a position to mark your answer, so you can use this knowledge. But here you the simply using an elimination method with the background knowledge background is not going to help you to answer, because the first is the factual has been stated that it is reasoned by Prison Act 1894. The first is prison. This has been given to the fact, and the second side is give power to provincial government. So we know that during this British era, whether it has been provided or not. So for this, it requires an exact knowledge. So yes, according to this question, according to the statement, this statement is also true. In India, the Prisons Act is governed through 1894 Act. This is a factual and this is correct statement. So if we mark the answer to this question, so answer to this question is both of the statement is true. It means it may be answer B or A can be the answer. C and D cannot be the answer, because both of the statement is true. Now in this type of questions where assertion and reasoning has been given, two statement is given, and the option says that both statements are correct and second is a correct explanation of first. So that requires to know that how to find that whether it is a correct relation explanation or not. So if we see that this is an effect and this is a cause, so we need to find which is a cause and which is an effect. So this is an effect because of this is happening. So because this empowers the state, because this Prisoner Act empower the state government to make regulations on the basis of how the state power gaining this power from where it is gaining a power from Prisons Act 1894. So on this basis we can say that this is the main cause or reasons and that this is an effect. So on the basis of if you are in a position to find the cause and effect, and if the second is a cause to the effect of the first, then the answer would be A. And if both are cause, A and 1 and 2, or both are effect or an independent cause and effect, then the answer would be B. But to this question, if we see, the answer to this question is A, that is B is a cause of statement 2 is an explanation, a correct explanation for the statement 1. Clear? Now if you see the logic for this question, this is a factual question. So if you see the facts, that prisons in India fall under the state list entry 4, that is list 2 of the 7th schedule of Indian Constitution, which means that the state governments have the power to manage and regulate prisons within their respective states. So on the basis of this, the first we can say this. Each state has its own prison manual governing the administrations, rules and regulation for prisons. So the first statement is true. If we see the second statement, that Prisons Act 1894 was the first legislation enacted by the British to regulate prisons in India. So the second statement, the first half of the second statement is also true, that Prison Act 1894, right? This act replaced the responsibilities of prisons under provincial government. This is also true. Both the facts true. Now it is an regulations. Can it be a cause where it gives power to state government, which later continues as a state subject in independent India. However, since then, various states have modified or replaced this act with their own prison manual, but still it has been continue or giving power to the states to regulate their own prisons and prisons related to administrations, rules and regulations. Clear? So this, by this we can say that it becomes a cause or it is a reasons why they have been empowered. So answer A, that is both 1 and 2 statements are correct and second is a correct explanation for the first statement. Hope you understand how to analyze and how to answer these types of questions where the two statements based on assertion and reasoning. Now what the UPSC do nowadays, that they give two statements. So we need to find that which one is an assertion and which one is an reason. So assertions would be in a form of effect and reasons would be in a form of cause, where it is originating the base for the given statement. So first we need to find whether the second is affect or first is affect. If first is affect, then second is cause or not. And on that basis, we can answer the questions. Clear? So moving to the next questions that was asked in 2023. Again in 2020, this is again a two statement is given, right? And if you analyze the option, so you will come to know that it is in the form of assertion and reasoning, that is in the effect on cause, effect and cause. So first of all, we need to find which is effect and which is cause. So let's say that consider the following statement. Consider the following statement. The first statement says, the Supreme Court of India has held in some judgments that reservation policies made under Article 16 Clause 4 of the Constitution of India would be limited by Article 335 for maintenance of efficiency of administrations. Right? The second says, Article 335 of the Constitution of India defines the term efficiency and administrations. It is defining the term. So the Constitution of India has not defined any types of term. There is no definitions given to the any kind of term used in the under the Constitution. So on this basis, if you are not sure about the first statement also, you can find that the second statement is incorrect, because it is saying Article 335 of the Constitution defines the term. So the Constitution mentions the term, but it does not define any terms. So on this logic, we can say that the second is incorrect. If second is incorrect, there is only one option we are left with, that is C, which says that the second statement is incorrect and the first is correct. The rest of the statements, options, that is A, B and C, all says that the second are correct, and second is correct. So in this logic, we can say that the only we are left with the options in this type of question is C. So our correct answer to this question is C. So from the two questions, that the first question is also based on an assertion and reasoning statement 1 and 2, and the second question in 2023 was also asked from these type of the same pattern. So what we need to do, the first of all, we need to find whether the both of this statement is correct or not. If both of the statement is correct, then we need to move further now to find whether the one is correct explanation of second or not. If we are in a position to find that the one of the statement given in the first and two of the statement is incorrect, then without moving further, we are in a very good position to answer the questions, because the option itself says that if one is incorrect, then we are very confident and we are in a very good position to answer the questions. An example is this questions where we need to find that second is incorrect, so we directly may mark our answer as C without analyzing any of the options, given options in the paper or questions. Is it clear? So it means this makes the first statement automatically true where the second is incorrect. Right? So if we see the explanations to this questions, the explanation says the Supreme Court has in multiple judgment like Indra Sahni case versus Union of India. This is related to Mandal Commission's case. This is also known as the Mandal Commission case. Mandal Commission case, where the 50% of the reservation ceiling is been done. Right, that the reservation cannot cross the 50% marks, where 27% of OBC reservations was done in the Indra Sahni case. And then another case is M. Nagaraj versus Union of India in 2006. So these are the two examples which talked in the questions that held that the reservation policies under Article 16 Clause 4 must be balanced with Article 335, which emphasizes the need to maintain efficiency in administrations. Clear? So on this basis, we can say that the first is correct. Now, what is Article 16 Clause 4 of the Constitution talks about? To say that it allows the state to provide reservations in public employment for backward classes, and this backward should be socially and educationally backward. Educationally backward classes, right? So this is Article 16. Article 16 is basically it prohibits the discriminations If it's, we all know that Article 16 talks about prohibition of prohibition of discriminations discriminations in public employment. In public employment. And this section is a part of right to equality. Right to equality. So it is a part of classifications of a right to equality. Clear? Now we'll see what is Article 335 says. So Article 335 deals with the claim of scheduled caste and scheduled tribes in matter of employment while maintaining administrative efficiency. So, what is SC/STs in public employment? A claim of a scheduled caste, scheduled tribes must be taken into consideration for appointment in government service and post. This ensures representations for historically disadvantaged community in the public employment. Okay, so this is one part of the 35 talks. Another part talks about the balance with administrative efficiency. So while providing reservations and opportunities to scheduled castes and scheduled tribes, efficiency in the administration should not be compromised. So efficiency, it does not mean the inefficient person should not be promoted, even in the reservation also. So if you are providing, so Article 16 clause 4, so Article 16 clause 4 talks about the reservations in employment. If you see this, so Article 16 clause 4 talks about reservations in employment, whereas 4A talks about reservations in promotions, and Article 4B talks about carry forward method. Carry forward method. So if anyone providing reservations in employment or in promotions after the employment, so during giving this reservation, the compromise of efficiency in administration should not be done. It means the inefficient person should not be given promoted or been employed under, because the reservation has to be given. It means that if a given set of seats has been reserved, suppose that out of 100 seats, 27 were reserved for the SC categories, but the commissions, the recruitment agency finds only 20 candidates suitable, which cross the threshold limit which has been decided by the commissions. So it should not take 7 extra who are not capable of the capable in terms of the testing agency. So it should, and if they take this 7, it means they compromise. So to maintain the efficiency of the administration, it should stick to this portion who has qualified and who has been in a position, who has been efficient to hold that post. So because, and this has restricted through the Article 335, and the remaining 7 will be carried forward in the next year of recruitment. Clear? So this means that it says that if we see again that while providing reservations and opportunity for scheduled castes and scheduled tribes, efficiency in administration should not be compromised. This means that merit and competency should also be taken into account while making appointment. So Article 335 of the Indian Constitution only mention about the efficiency in administration and does not define the same term. So Indian constitutions mostly at the most of the place, 95% of times it only mentioning, or even the 97-98% of the time it is only mention the term, it does not define. So on this logic also we can say that the second statement is true, and if we in a positions to make eliminate either of the statement as an incorrect, then we are in a very good positions to answer this question. Clear? Hope this is clear now. Now let's move to the next questions. Next question was asked in 2022. So it has given a 4 statement. So it says that consider the following statement. So let's see the let's analyze the 4 statement. It says that pursuant to the report of H.N. Sanyal Committee, the Contempt of Court Act 1971 was passed. This is a very factual question, a fact-based question. So if you are If you know exactly, you can answer. If you do not know, there is no need to panic. Just move to the second statement. So because we have a four of the statement given, so we can analyze now. If you are in a positions to eliminate, we can do that. So if you are in a positions to know this exactly, so it is good, you can mark your answer. If no, if you do not know, it means you are not. If, then there is no need to panic, move to the next. Before that also, if you analyze the given option, so if you see that first statement is paired with 2 or 4. If the third statement, it means the first is not first and third are opposite. If so, what does it mean? That if we find that the third is incorrect or correct, then automatically the reciprocal of that one would be the correct or incorrect respectively. So through analyzing the options, so what we can do, going to, instead of going to second statement, just move to the third statement and check whether the third statement is correct or not. If the third statement is correct, so it means the A and B cannot be answered and the first is incorrect. Outright it will be incorrect because there is no combination of 1 and 3 in the given option. So let's see the third statement. So the third statement says the Constitution of India defines civil contempt and criminal contempt. No, it is incorrect. The contempt of court is only mentioned in the Constitution of India, but it does not define. So it not define the contempt of court, right? Even the civil and criminal contempt is also not mentioned in the Constitution of India. It only mentions contempt of court, and we know that contempt of court can be in a civil matter or in a criminal matter, but it is not defined. So on this logic, we can say that the third is incorrect. So if the third is incorrect, so we can say that C and D cannot be the answer. So only analyzing the two statement, first and third statement, we are in a very good position to mark our answers. And if the third is incorrect, so the first is automatically correct. So if now the benefit you can see here, that if you know the first exactly, also then also is good. If you do not, if you have no idea about the first statement, now you are in a position to find that yes, first is true. And along with that, second is also true. So without analyzing the second, we can say that the second is true because there is a combination in the both of the two statements, 1 and 2 is there. So we only need to analyze the fourth statement, whether the fourth is true or not, right? But let's, as we are discussing the question, so let's see the second statement also. So the Constitution of India empowers the Supreme Court and High Court to punish for contempt for themselves. Yes, it is true. Through court of record. This is one of the power of the Judiciary, Supreme Court and High Court. So through the power of court of record, this has been, through this power, the contempt of court has been given to both of the statement, both of the judiciaries for themselves. It means Supreme Court and High Court has been empowered to punish for contempt. So second is also true. Now moving to the first. In India, the parliament is vested with the power to make laws on contempt of court. Now it is as a power. So if you see the fourth and the first statement, the first says that on the report of H.N. Sanyal, Contempt of Court Act was passed, which is true. So it means it is that only the legislative authority in India is parliament and state legislature. Right. But here talks the contempt of court is for the Supreme Court and High Court. So there is no power given to the Supreme state legislature with respect to Supreme Court and High Court to make any regulations. Only a parliament who can make laws. So on the, if we analyze deeply through the first and fourth also, we can say yes, if first is true, the fourth has to be true, because first says that on a report of H.N. Sanyal, Contempt of Court Act was passed, and it is only the two authority in the India who can make laws, either the parliament or state legislature. But the subject matter of contempt of court, which deals with the Supreme Court and High Court, it is only authority who is the parliament who can make law. So yes, this is true automatically when we see this. So this is how you can use your knowledge your knowledge based ground to make and mark an answer. So this questions, the third question of 20, the questions of this statement, we have just analyzed that we have just correctly know the third statement is incorrect. On the basis of that, on the logic which we apply, so we can mark our answer. So how this is how you can use your knowledge based ground to come up with the correct answer if you have little bit knowledge or little bit idea about the questions. Hope this helps you in the examinations, and to help get help out of this, you need to practice lot more of these types of trick or not. These are not tricks. These are not, which we cannot call it as a trick or cheat code. These are not cheat codes or trick. This is basically you use your logic. So these are based on the logic. So if you need to use this logic in examinations where you can find कि ऐसा लॉजिक कैसे यूज होगा. So for that what you need to do is you need to practice more of these type of, whenever you find a questions, try to use the logic of this. Clear? So let's see the explanations to the given questions. So the H.N. Sanyal Committee of 1961 was appointed to examine the law relating to contempt of courts and make recommendations for the reform. Based on his report, the Contempt of Court Act 1971 was enacted to define. So this act has defined the contempt of court and regulate contempt of court in India. Yeah. Now Article 129, according to Article 129, grants the Supreme Court of India the status of court of record and give its power to punish for contempt of court. So under the court of record power, it has a contempt of court power. The Supreme Court has a court of record, which means judgment, proceedings and records have permanent legal authority. These records cannot be questioned in any lower court. They serve as a legal precedent for future cases. Power to punish for contempt of court. The Supreme Court has a power to punish individuals or entities for contempt, which includes civil contempt, that is willful disobedience of court order. Criminal contempt, any act that scandalize or lower the authorities of court. This power ensures respect for the judiciary and protects its dignity and authority. Clear? So this, and similarly there is a law related to the High Court also, which has been power to contempt of court under court of record. Clear? So hope this as gives you a confidence also, and it will also provide you the way how you can deal the questions in examinations. Let's see the another explanation to this question. So Article 215, according to Article 215 of the Constitution, which grants High Court the status of court of record and empowers them to punish for contempt of court. High Court has a court of record, which means judgment, proceedings and records have permanent legal authority. These records cannot be challenged in any lower court. They serve as a legal precedent for future case. Power to punish for contempt. So High Court have that authority to punish individuals or entities for contempt of court, which includes civil contempt, which means willful disobedience of court order. Criminal contempt, acts that scandalize, obstruct or lower the authority of court. So this is the similar with that of Supreme Court. So the Constitution of India does not define the civil or criminal contempt. These definitions are provided under the Contempt of Court Act 1971, which classifies into two things. That is, what do we mean by the civil contempt? So it means a willful disobedience of a court order. What do we mean by the criminal contempt? So any act that scandalizes or lowers the authority of the court, prejudice judicial proceedings or obstruct the administration of justice. So this has been given in definitions in the Act of Contempt of Court Act 1971. The Parliament has a power to legislate on contempt of court, which is under entry 77 of the Union List, that is 7th schedule. So Parliament enacted the Contempt of Court Act 1971, which applies to both the Supreme Court and High Court. And as we know, that the only two authority in India which can make laws, that is Parliament and state legislature, but it is a subject matter of judiciary, so it comes directly. We have an integrated judiciary, so that has been all the laws related to judiciary has been made through the Parliament. Is it clear? Let's move to next question. Next question was asked in 2022. So it says that with reference to India, consider the following statement. Now the two statement is given, 1 and 2, and here we need to find the correct answer. So let's see the first statement, that government law officers and legal firms are recognized as advocate, but corporate lawyers and patent attorney are excluded from recognition as advocate. So this is a very fact questions, fact-based questions. So if you know, you can answer. If no, it is advisable to leave these type of questions. जितना टाइम आप इसमें लगाएंगे, इससे बेटर है कि you will be, there will be more questions where you can, the chances are कि आप उसको easily correct कर सकते हैं. ठीक है? So is this correct? No, this is incorrect. Why? Because legal firms are not advocate. ठीक है? Government law officers are advocate, corporate lawyers are advocate, but legal firms are not advocates. So this is incorrect statement. If you see the bar council have the power to lay down the rules relating to legal education and recognition of law colleges. Yes, it is true, because it is a bar council who has been empowered to register the advocate and also to see whether they have been done from the recognized university or not, to grant a recognition to the university, which university or colleges can provide the degree or validation of that degree. So it is true. The second is true, but first is incorrect. So our answer to this question is B, that is only 2 is correct. Now if you see the explanations to these questions, which says that Advocate Act 1961 defines who can recognize as an advocate in India. So who can recognize? First, the government law officers like Attorney General, Solicitor General, additional Solicitor Generals are considered as an advocate. Legal firms are not recognized as an advocate. Only individuals lawyer enrolled with the State Bar Council as recognized lawyer. So only individual can register themselves as a lawyer. Right? Now, corporate lawyers and patent attorney may or may not be recognized as advocates depending on their enrollment with Bar Council. So if they are registered with the Bar Council, they will be recognized. If they do not register with Bar, they will not be recognized advocate or lawyer. If they are not enrolled, they are not recognized as an advocate under the Advocate Act 1961. Clear? So so because on the logic of this, the first is incorrect. Now if you see the explanation for the second statement, which says that Bar Council of India is responsible for laying down standard of legal educations in consultations with the universities and regulating legal education in India, recognizing law colleges and prescribing conditions for their affiliations, setting rules for qualifications and enrollment of advocates. This power is granted under the Advocate Act 1961. So the Bar Council get this kind of act through the Act of 1961. So on this logic, the second is correct statement. Clear? So this is a factual question. You need to have the ideas about this. Let's move to the next questions. Next question asked in 2021. So again, there is a two statement. It says that with reference to India, consider the following statement. So judicial custody means an accused is in custody of concerned magistrate and such accused is locked up in the police station, not in jail. Second says, during judicial custody, the police officer in charge of the case is not allowed to interrogate the subject without the approval of the court. So this is also some kind of fact questions, fact-based questions. So if we analyze the two of the statement, we need to find the correct answer. If we analyze the two given statements, so the first says that judicial custody means an accused is in custody of concerned magistrate and such accused is locked up in the police station, not in jail. This is incorrect because there is two types of uh, custody. One is judicial custody and another is police custody. So police custody means when the accused is in jail, where the police are free to interrogate them. That's why the police sometimes asks, if you might have gone through the newspaper, तो आपने देखा होगा the police is asking for a custody, but the judiciary, but the court, court allowed to a judicial custody, means they send them to jail till the next hearing. So in judicial custody, the accused will be locked up in bail. Sorry, in jail, not in bail. Sorry, in jail. But where in the police custody, they are in the police stations. Police stations, they have been locked up. Okay? So the according to this, the first is incorrect. Not they are in the police station, not in jail. No, they are in jail, but not in police custody. Only they will be in the police stations when they are been granted a police custody. So police custody means in the custody of police, and magistrate judicial custody, they are in the custody of magistrate, so they can be sent to the jail. So on this logic, the first is incorrect statement. If we say the second statement, during the judicial custody, the police officers in charge of the case is not allowed to interrogate the suspect without the approval of the court. So yes, if they are locked up, if they are sent in the jail, if they are in the jail, so they are not free to interrogate. They are only police will be only free when they are in the police stations. So for jail, they have to take up permissions of the court, and also the accused advocate need to be present at the time of interrogations. Then only the police can interrogate the accused. So this is the second statement is true. So we can say that the answer to this question is B, that is only 2 is correct. Clear? So now if you see the explanations to these questions, that the provisions for custody in India are governed by the section 167 of the Code of Criminal Procedure. A person may be held in custody of police or in judicial custody. Judicial custody refers to the detention of an accused under the authority and supervision of judicial system, that is magistrate court. When an accused is sent to judicial custody, they are typically housed in jail and not in police stations. The police custody refers to a period when an accused is kept under the physical custody of police for investigation process, which is distinct from the judicial custody. Once accused is sent to judicial custody, they are under the supervision of court and cannot be interrogated by the police without permission of the court. If police wants to interrogate the accused, they must seek court permissions. To do so, the court ensures that the rights of the accused are protected during the period of judicial custody. So the difference between the police and judicial custody is that they will lock up in judicial custody, they will be in the jail, and in police custody, they will be in the police stations. Clear? So this is the questions asked in 2020.